Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney who does estate planning, focusing on long-term care needs, commonly referred to as Medicaid planning, and I do probate, and I do it well. Today I wanted to talk to you about arbitration provisions in long-term care contracts, so nursing home contracts or assisted living facility contracts. Historically, in the past, some, not all, but many of these facilities would require residents to consent to an arbitration agreement as part of their contract to receive care at their facility. And some of these facilities even made admission, meaning you being allowed to live there, made it a mandatory requirement that a future resident consent to arbitration before they would be admitted to the facility. And as you can imagine, when people are shopping for long-term care needs in nursing homes, it's an overwhelming and stressful procedure, right? You're looking for the best place for your relative. You want to make sure your relative likes the place, that they feel at home and comfortable, and that the people are nice, and the smell is good, and the food tastes yummy, and all of these things, and that it's close and convenient for frequent visits and visitors and trips to your medical providers. And then the time comes for you to sign the contract, to enter into a residency agreement, and the contract it's a big legal document, and there's a lot of terms. And at that time, then they were presented with this contract that includes this mandatory arbitration clause, and people don't really even know what that means. And they would sign the contract, and then when trouble would hit and they felt as if they had some sort of legal cause of action against the long-term care facility, they would learn that they had agreed to attend mandatory arbitration and that they were not able to file a lawsuit before a court. So just a brief high-level summary of what arbitration is. Arbitration means you don't go before a judge, you don't go in what they call the court of law. Instead, you go before a neutral who's called an arbitrator. It's similar to a mediator, but this person is a decision maker. And in arbitration, you would present your evidence to this neutral, this arbitrator, but the rules of evidence that you would find in civil court are not the same as the rules of evidence in arbitration. They're more relaxed. In arbitration, you could bring in hearsay, which would not be permissible in the court of law. So there's just different rules that apply. And the decision could be binding and affect your ability to for certain appeal rights. So it would just be a different process and might not be the ideal process for the resident. There are benefits to arbitration. Generally, it keeps the case out of the public eye. It's much more of a private resolution, which might be a good thing for the nursing home facility because they don't have it in the news, and it wouldn't be part of public record because it's a more closed and private proceeding. So there are pluses and minuses to arbitration. Arbitration might be a great thing and it might not, but forcing people to waive their right for a lawsuit and enter into an arbitration, consent to arbitration as part of their contract and admission, the Center for Medicaid and Medicare felt that was inappropriate, and in their rulemaking, they had changed the rules to say that was forbidden, which resulted in a lawsuit. And so in response to the lawsuit, the agency changed their rules, and now the rules say that nursing home facilities, long-term care facilities may have arbitration provisions in their contract, but it can't be mandatory. A resident needs to consent to it and not have it mandatory. You won't be admitted to our facility unless you agree to this provision. No, you can, as a resident or a future or prospective resident, either opt in or opt out. And whether you opt in or you opt out, that doesn't mean that we don't have a space for you at our facility. You will still have a space. And the other thing that it says, the rules say, it says that this provision needs to be written in plain language and be very clear, so that way people know what they're agreeing to when they opt in or opt out of arbitration as the dispute resolution method to any contract things. Also, the rule said that the resident needs to know that just because there is this arbitration provision, whether they opt in or opt out, they still can file complaints against the nursing home to the state agencies and the regulatory boards if they believe that there are violations of any sort of health code or just licensing issues. Essentially, we just don't want it to stop whistleblowers. So residents and their families, the contract needs to be clear that they still maintain the right to be able to call and report any concerns that they have to the government authorities, so that way they can be investigated. And what is the other one? Oh, the other term that it says is that it needs to be clear that should a resident agree to engage in arbitration, that the location would be convenient for both the resident and the facility. So it's not going to be that I agree to arbitrate and it's a Florida-based facility and they tell you you're going to arbitrate in Nevada, for instance. That might not, most likely would not be convenient for the resident, and therefore, even if the headquarters of the long-term care facility would be in Nevada, we're not going to have contracts that say that. The neutral arbitrator needs to be agreed upon by both parties, and the location needs to be a central and agreeable location for all parties as well. So whether or not you should sign this nursing home contract, whether or not you should opt in or opt out of arbitration, that is a personal decision for you. I would encourage you, if you don't understand the terms of the contract and you aren't sure what it means and what you will be signing, that you take it to an eligible law attorney to review with you and your family, so that way you know what you are agreeing to. There's nothing that would prevent you from saying, I'd like to take a copy of this contract with me and go ask my attorney to help review it with me. A long-term care facility, that's a completely reasonable request, and they're going to allow you to do that. So there should be no pressure at that time to just sign right then. I mean, of course, it would impact timelines as to when you can move in and if that's an urgency, but I still would encourage you, if you don't understand what you're signing, to seek out legal counsel, have it explained to you in words that you do understand, so that way you know what you're giving up or what you're not giving up. And just know that you could always agree to arbitrate later. So even if you opted out of arbitration and say, nah, I don't want to agree to arbitration at this time, later on, if there is a dispute, you could still say, you know what, I'd like to arbitrate this. I don't want to, a lawsuit's expensive, and that's just not the way I want to go, and I would rather engage in arbitration. You could still do that at a later date. So just because you don't opt in right at the time that you sign your contract for admission doesn't mean that in the future you couldn't participate in arbitration. That it would still be a door that's most likely available to you, because I can't imagine a nursing home saying no, that they wouldn't want to engage in that. It's possible, but the likelihood is that door is still open for you in the future. I hope that this information has been helpful to you. If it has, I ask that you like and share with others. And as always, thank you for joining me.